The 67th ministerial press briefing continues less than 48 hours to the presidential elections. The Attorney General of the Federation and Minister of Justice, who is also being sued for contempt of the court by some state governors, expectedly illuminates on the subject of the Naira redesign.
Well, generally
speaking against a backdrop of pockets of disenchantments over the president's recent broadcast, restoring only the validity of the old 200 Naira notes, Mr. Malami absolved the president of blame.
Where an order is made by a court, you have multiple options. But let me state, before even addressing the issue of the options available at our disposal as a government, the fact clearly that we are not in breach of any order made by the court, inclusive of any order associated with the Naira redesign. We are not in breach. I believe, I'm not a banker, but you have not gone further to establish which bank is it that you have gone to present a 1,000 or 500 Naira note that has been rejected. The matter is sub judice, and within the context of this rule of law, we are doing the needful as a government in terms of ensuring that the right of the government within the context of the Naira redesign is being protected. So we are not in breach.
He equally highlights the importance of the redesign policy and the impact of the Electoral Act, underscoring that they were essentially constituted to enable citizens to assume collective ownership of the electoral system rather than allowing a few money bags to take charge.
Simply because I have succeeded in raising, perhaps legitimately or otherwise, 200 billion, I can now come out to fight a system that is battling to address transparency, to address visibility of the process out of desire to limit corruption. So it is about people, limited number for that matter, that have succeeded in having at their disposal resources that they are protecting. And then again, forcing a compromise on a policy that is beneficial to 200 million Nigerians. Our interest is not a fraction but a whole.
While counting the gains of the extant 2022 Electoral Act, the Chief Law Officer maintains that there are no pre-election matters in the Supreme Court, unlike what was tenable in 2010. He's also corroborating the position of the Inspector General of Police, who says that investigations are ongoing on those individuals and even state governors who have purportedly made treasonable utterances in the last few days. From the presidential villa, Gloria Umezuke, Channels Television News.